A single question, 11 words long, is about to determine whether roughly a dozen state gun laws survive or collapse, and the Supreme Court chose to answer it on the very last day of its term, after years of deliberately looking the other way. On June 30th, 2026, the court granted certiorari in Viramontes v. Cook County and Grant v. Higgins, consolidating them for a single hour of oral argument on one narrow question: whether the Second and 14th Amendments protect the right to possess AR-15 platform and similar semi-automatic rifles in common use. Here is what almost no coverage explained clearly. The court has been avoiding this exact question for years, repeatedly declining review in similar cases, and understanding why it finally agreed to take this one up now tells you almost everything about how the eventual ruling is likely to unfold. This is not a story about one weekend's headline. It is a story about how the Supreme Court decides which fights are actually ready to be settled, and why these two specific cases, out of dozens of possible vehicles working through the lower courts, were the ones the justices finally chose. Before I walk through the procedural history behind these two cases and why the timing matters as much as the substance, hit subscribe, because oral argument is coming this fall and I am going to break down the briefing, the amicus filings, and the argument itself the moment each one happens. Tell me in the comments what you think tips the balance here: national ownership statistics showing how common these rifles actually are, or historical evidence about which weapons the founding generation would have recognized as protected arms. Both sides are about to make that exact argument, and I want your honest prediction. Let's start with the procedural path that got these cases here, because it explains a lot about why the court finally acted. Viramontes v. Cook County traces back to an ordinance Cook County, Illinois passed in 1993, banning the sale, transfer, and possession of assault weapons, defined to include AR-15S, AK-47S, and roughly 125 specifically named rifle models, along with magazines over 10 rounds. That ordinance became the direct model for a nearly identical statewide ban the Illinois legislature later enacted, which means the legal reasoning in this case extends well past Cook County's own boundaries and effectively puts the entire state's assault weapons framework at stake in a single ruling. Cuthberto Viramontes, Christopher Kaya, the Firearms Policy Coalition, and the Second Amendment Foundation filed suit in August of 2021, and the case worked its way to the Seventh Circuit Court of Appeals, which upheld the ban, leaning heavily on its own earlier precedent from a related Naperville, Illinois case that has effectively governed how that circuit handles assault weapons challenges ever since it was decided. Grant v. Higgins followed a separate but parallel path, challenging Connecticut's ban on semi-automatic rifles acquired after April 3, 2013, restricted both by specific model name and by a broader feature-based definition designed to capture rifles that share certain characteristics even without appearing by name on the statute's list. The Second Amendment Foundation and the Connecticut Citizens Defense League brought that challenge, and after what the challengers called a troubling and misguided preliminary injunction ruling, the Second Circuit ultimately upheld Connecticut's law as well, closing out both cases at the appellate level with the same underlying outcome. Now here is the detail that separates this cert grant from a routine circuit split resolution, and it is worth sitting with for a moment. Both the Seventh Circuit and the Second Circuit upheld the bans they reviewed. This is not a case where two circuits reached opposite conclusions and the Supreme Court stepped in to referee an obvious disagreement between them. According to tracking by gun control advocacy organizations, 6 separate federal appeals courts have now upheld assault weapon and magazine capacity restrictions in some form, spanning multiple states and multiple different statutory approaches to defining exactly which weapons and features fall under each ban. The lower court landscape, in other words, has consistently sided with the states defending these laws for years, with only scattered exceptions breaking from that pattern. That makes the court's decision to grant certiorari here genuinely different from a typical circuit split case, because the justices are choosing to revisit a question where nearly every circuit that has addressed it has landed the same way, upholding the restrictions rather than striking them down, which raises the obvious question of why the court would bother taking up a case where the lower courts have been this consistent, rather than simply letting that consistency stand as the settled national answer. That pattern of consistent lower court rulings is exactly what makes the timing of this cert grant so significant. Justice Kavanaugh had signaled roughly a year earlier, in connection with the court's decision to deny review in an earlier related case, that the court should and presumably would address the AR-15 issue soon, in the next term or two. That was widely read as a warning to the lower courts and to litigants alike that the court's pattern of denying review in these cases was not going to continue indefinitely, even as the justices kept passing on individual opportunities to weigh in. The petitions that eventually became Viramontes and Grant were exactly the kind of vehicles Kavanaugh's comment anticipated, cases with fully developed records, clean procedural postures, and squarely presented questions about the same defined category of firearm. When the court finally granted certiorari on the very last day of its term, it was closing out a pattern of anticipation that had been building for roughly a year inside the gun rights legal community. Let's talk about the specific language of the question presented, because Supreme Court practice treats that wording as a genuine constraint on what the eventual opinion can actually decide. The court granted review limited to whether the Second and 14th Amendments protect the right to possess AR-15 platform and similar semi-automatic rifles in common use. Notice that this framing borrows directly from the historical tradition test the court established in its 2022 Bruin decision, which asks whether a modern firearm is in common use by law-abiding citizens for lawful purposes, since items meeting that description generally fall within what the plain text of the Second Amendment protects, subject to the government then proving a genuine historical tradition justifying any restriction. By framing the question this way, the court has essentially pre-committed to litigating this case primarily on ownership and usage evidence, national sales figures, survey data on how many households own these rifles, and comparative statistics about how frequently they appear in the overall universe of firearms used in crime versus how frequently they are owned lawfully. Expect Cook County and Connecticut to counter that framing directly, arguing that common use cannot be the only relevant inquiry, and pointing to the disproportionate role these specific rifles play in mass casualty shootings relative to their overall ownership share as a separate justification the historical tradition test should still accommodate. There is a broader legal current running underneath this cert grant that connects directly to rulings we have covered before. Just weeks before the Supreme Court granted review here, the Third Circuit, sitting en banc, struck down New Jersey's own assault weapons ban and magazine capacity restriction in a 10-5 ruling, reasoning that semi-automatic rifles and standard capacity magazines are commonly owned and therefore constitutionally protected. That ruling directly conflicts with what the Seventh and Second Circuits concluded in Viramontes and Grant, creating exactly the kind of fresh, live circuit split that gives the Supreme Court both a legal reason and a practical urgency to settle the question now rather than later, since three different circuits are now actively disagreeing about the same underlying category of firearm within the span of a few weeks of each other. The Justice Department itself has also weighed in on this side of the debate in related litigation, filing briefs supporting Second Amendment challengers against similar state restrictions, which tells you the federal government's current litigating position leans toward treating these rifles as protected rather than restrictable, a posture that is likely to carry over into whatever the federal government files in Viramontes and Grant themselves once briefing formally begins. Here is what to actually watch for as this case develops over the coming months. Briefing schedules had not been finalized as of the cert grant, but expect merits briefs from both sides, along with amicus briefs from an unusually large coalition on each side: gun rights organizations, gun control advocacy groups, medical and public health associations, law enforcement organizations, and a substantial number of state attorneys. General filing in support of whichever side matches their own state's law, since a ruling here will directly affect statutes. Those officials are personally responsible for defending or, in some cases, enforcing. Oral argument is expected this fall, likely between October and December, consolidated into a single hour with time divided between the two cases, meaning both legal teams will need to be efficient and focused in a way that longer single-case arguments do not require. A decision is expected sometime before the court's term concludes, most likely in the late spring or early summer of 2027, consistent with the court's typical pattern of releasing its most consequential rulings toward the very end of its annual calendar, often on the final days before the justices break for summer recess. Step back and look at the full shape of what is actually happening here. The Supreme Court spent years declining to answer this exact question, watching circuit after circuit uphold assault weapons restrictions with only isolated exceptions. It finally agreed to step in only after a justice publicly signaled the wait was ending, and only once a case record existed clean enough to decide the question squarely, right around the same moment a different circuit broke sharply from the pattern everyone had assumed was settling into place. That sequence tells you this was not an impulsive decision. It was a deliberate, carefully timed choice to finally resolve a question the court had been watching accumulate conflicting answers underneath it for years, and the ruling that follows is going to carry weight well beyond the two specific laws actually named in these cases, reaching into the legal status of similar restrictions in every state that has one currently on the books. If this gave you the real procedural story behind why this case is happening now, rather than the flattened breaking news version circulating everywhere, hit that like button so more people find the accurate explanation. Subscribe, because I am tracking every filing in this case from now through the ruling itself, and this is going to be one of the defining Second Amendment moments of the decade. Comment below and tell me whether you think the court's decision to grant cert here, right after a fresh circuit split emerged out of New Jersey, was coincidental timing or a deliberate signal about which way this is heading.